Hello, my name is Danilo Ruggero di Bella. I'm a lawyer admitted to the Madrid bar, working at the law firm Bottega di Bella, and today we are going to master how to draft effectively a valid and enforceable arbitration agreement. You see, the arbitration agreement is the backbone of arbitration, so it is critical that you get it right. It represents the parties' will to preclude recourse to state courts in favor of a private dispute resolution mechanism. There exist two forms of arbitration agreement: an arbitration clause embedded in a contract to have future disputes between the contracting parties settled by way of arbitration, or a document called arbitration submission that is drafted and agreed by the parties to solve a dispute that is already in place. The arbitration submission is usually more detailed than an arbitration clause, as it contains the specifications of the dispute already arisen. Generally, a formal requirement for an arbitration agreement is to be in writing and signed by the parties, at least to benefit of enforcement according to Article 2 of the New York Convention. As technology rapidly evolves, and so does the way deals are closed, the requirement of being in writing can be satisfied by an exchange of emails confirming parties' agreement to arbitrate. In any case, it is always safer to check the lex arbitri, which is the arbitration law at the seat of the proceedings, to verify whether it requires a special form for the arbitration agreement in order to be valid. There is no magic formula when drafting an arbitration agreement. However, in all cases, parties should give careful consideration to the following issues: the scope of the arbitration agreement, the procedural rules, the number of arbitrators, the language of the proceedings, the applicable law, and the seat or place of the arbitration. The scope of the arbitration agreement is the type and ambit of disputes that the parties have agreed to submit to arbitration. The scope sets the limits of the arbitrator's mandate. If the arbitrator does not strictly abide by those limits, the resulting award could be either annulled at the seat of the arbitration, or its recognition could be denied in the foreign jurisdiction where enforcement is sought. Imagine all the time and money spent for nothing. For this very reason, the scope of an arbitration agreement should be defined very broadly, so as to cover all disputes arising out or in connection with the commercial relationship of the parties. Now, if the parties want to limit the scope of an arbitration agreement, or to exclude some dispute from its purview, they can do it by expressly stating so. However, parties should be aware that by doing so, they may unintentionally open the discussion down the road about the applicability of the arbitration agreement to a given dispute. Therefore, it is recommendable an all-encompassing arbitration clause that recites as follows: all disputes arising out or in connection with the contract, including any question regarding its existence, validity, or termination, shall be finally resolved by arbitration. By selecting the procedural rules, the parties effectively choose the procedural framework that will govern the arbitral proceedings. The parties may choose a set of institutional rules, thus opting for an institutional arbitration, where an arbitral institution will administer the proceedings, which is always the recommended option. Or the parties may opt for an ad hoc arbitration by creating their own procedural rules or using existing arbitral rules such as the ancestral arbitration rules, or relying on the national procedural law of the place of the arbitration. As to the institutional rules, it is important to note that they are amended from time to time to keep up with the latest trends in the arbitration arena. As a consequence, the institutional rules at the time of the entry into force of the arbitration agreement may differ from the institutional rules at the time of the actual commencement of the proceedings. It is understood that the parties, when submitting their dispute to arbitration, have implicitly agreed to the latest amended version of the rules, unless they clearly specify they want to apply an older version of the rules by mentioning their preference in the arbitration agreement. With regard to the arbitral tribunal, both institutional rules and ad hoc arbitration rules usually provide for a default method for appointing arbitrators. The parties should specify in their arbitration agreement the number of arbitrators. The typical choice is between a sole arbitrator and a three-member tribunal, depending on the value of the dispute and its complexity. The number of arbitrators must be an odd number, since an even number may stall the decision-making process, besides being forbidden under certain arbitration laws. Generally speaking, a sole arbitrator tends to be constituted more rapidly, conduct the arbitration more expeditiously, and cost less than a three-member panel. Conversely, a three-member tribunal takes longer to be set up, it may experience difficulties in scheduling the proceedings, and need more time to deliberate. And of course, it is more expensive. On the other hand, it is also true that in comparison, the parties get triple the expertise of a single arbitrator. In case of an ad hoc arbitration, parties should consider selecting and appointing authority to designate the arbitrators so that the proceedings are not delayed by the inaction of the defaulting party or by a disagreement between the parties. In the arbitration agreement, the parties should also specify the language of the proceedings. In making the choice, regard should be given to the language of the contract, as well as the likelihood of finding qualified arbitrators and counsels proficient in that language, as written submission and oral pleadings, including expert and witness examination, will be carried out in the chosen language. Sometimes, an arbitration agreement may prescribe to conduct the proceedings in multiple languages. In these cases, multiple languages could be used either interchangeably, without any translation or interpretation, or in parallel, meaning each communication and document must be translated into all the languages of the arbitration. Although this option accommodates the need of parties coming from different jurisdictions, it may result in increasing exponentially the cost of the whole arbitration. In order to save on translation cost, the arbitration agreement may choose one language, but allows documents to be admitted in different languages, provided that the arbitrators and the counsel have a good working level of those other languages. In the absence of a chosen language in the arbitration agreement, it is up to the tribunal to determine the language or languages of the proceedings. The parties should clearly state in the arbitration agreement the lex contractus, which is the substantive law of the contract applicable to the merits of the dispute. The parties are free to choose whatever law or rules of law they deem fit for their commercial relationship. Parties are not obliged to apply the national law of the country where they operate or where the contract is to be performed. Parties are not even obliged to choose a specific national legal system as lex contractus. Instead, they may choose a set of rules of law, such as general principle of law, public international law, or transnational laws like lex mercatoria, trade usages, the unidroit principle, or even require the tribunal to decide ex aequat bono. If the parties fail to state the applicable substantive law or fail to agree on whatever law that is, the tribunal will determine it. The parties should identify the place or seat of the arbitration. The seat of arbitration is the national legal system where the arbitration shall be anchored, as international commercial arbitration does not occur in a legal vacuum. The place of arbitration determines the lex arbitri, that is, the applicable arbitration legislation which governs the procedural aspects of the arbitration. The judge at the seat of the arbitration may provide assistance to the arbitral proceedings and will be competent for any application to stay the proceedings or to set aside the resulting award. As a rule of thumb, parties should opt for a state that is a contracting party to the 1958 New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which makes possible to have an award enforced in 159 states. If the seat of arbitration has not been agreed by the parties, typically the tribunal in ad hoc arbitration or the arbitral institution administering the case will determine the seat at the outset of the proceeding. Some institutional rules include a default place of arbitration, in case the parties have not chosen one, such as the London Court of International Arbitration. Parties should not include any incorrect, ambiguous, unclear, or contradictory information in the arbitration agreement that may result in a pathological clause delaying or even derailing the proceedings. For example, a clause can be considered pathological when it refers the dispute to an arbitral institution by misciting its name, or even worse, to a non-existing institution. Additional elements to an arbitration agreement may include a multi-tiered clause providing for a timetable for negotiation and mediation preceding arbitration, a state immunity waiver when contracting with a state or a state authority, confidentiality obligation, allocation of costs and fees, reference to the IBA rules on taking of evidence in international arbitration, and more in general, any provision the parties deem appropriate to customize their procedure. Thank you for watching, see you next time, and don't forget to take the multiple choice test that you may find down below by clicking on the link in the description of the video and get your certificate of Arbitration with Passion, how to draft an arbitration agreement, powered by Bottega di Bella. Now I leave you with several templates of arbitration agreement prepared by renowned arbitral institutions, namely the ICC, the Corte de Arbitraje de Madrid, the London Court of International Arbitration, the Milan Chamber of Arbitration, the Florence Chamber of Arbitration, the Venice Chamber of Arbitration, and the Court of Arbitration of Alicante.